Sorry, folks. We had a bit of a technical glitch there. I will get us started again. Sorry about that. Good afternoon. Welcome to Changing Landscapes, our court watching report release event. My name is Matthew McLaughlin. I've just started using the internet for the first time. The Illinois Network for Pretrial Justice is a statewide coalition of more than 40 community, faith, and policy organizations working together to end money bond and reduce pretrial jailing across our state. In 2020, we worked with the legislature to pass the Pretrial Fairness Act, historic civil rights legislation that made Illinois the first state in the country to completely end the practice of money bond, the practice of charging people for their freedom while they await trial. Ending money bond was always our target, but pretrial freedom was the real goal of the Illinois Network for Pretrial Justice. And the Pretrial Fairness Act includes a number of important provisions that are helping make that a reality. Namely, the law affirms the presumption for pretrial release. It places important limits on pretrial incarceration and increases the amount of time and information that judges are receiving when making release and detention decisions. 3 years into implementation, we have seen a reduction in both violent and property crime across Illinois, a far cry from the purge that was predicted by law enforcement officials and conservatives. We've also seen fewer people incarcerated pre-trial statewide, but unfortunately, 3 years into implementation, we're now seeing some disparities in outcomes based on what county your pre-trial hearing occurred in. Notably, that's happening right here in Cook County, home to Illinois' largest court system. Over the last year and a half, we've seen a rise in pretrial incarceration in Cook County, namely due to policies put in place by Cook County State's Attorney Eileen O'Neill Burke that are undermining the intentions and goals of the Pretrial Fairness Act. The Illinois Network for Pretrial Justice trained up court watchers to go into court so that we could get a better understanding of what was happening and what needed to be done in order to improve implementation. This was extra important because there is a lack of data available regarding the Pretrial Fairness Act, namely because the state has failed to implement the data collection and publication provisions included in the law. State's Attorney Eileen O'Neill Burke has also reduced the amount of data being released by the Cook County State's Attorney's Office. We've seen the power of court watching. In 2017, our coalition trained up more than 100 people to watch pretrial hearings in Cook County when the county implemented General Order 188A, a reform intended to have judges setting bonds at amounts that people could afford to pay. When that reform was implemented, that was not the outcome that we were seeing. And so we trained up court watchers. We used their findings to influence stakeholders and shift implementation of that reform and ultimately reduce the number of people in Cook County Jail by over 2,000 people on any given day, which is why in the spring of 2025, we trained up 50 court watchers who observed pretrial hearings for several weeks at the Layton Criminal Courthouse. They ultimately observed 167 hearings. Our coalition then engaged in data analysis. We came up with qualitative and quantitative findings based on what the court watchers observed. We also compared that information to what we saw when the law first went into effect. The report, Changing Landscapes, also features recommendations for each stakeholder. I'm excited to get the rest of this event going. We've got Austin Siegel from Chicago Appleseed, who will be presenting the findings of the court watchers. We'll then be joined by Catherine Crawford from the Illinois Network for Pretrial Justice, along with Cook County Public Defender Sharone Mitchell, State Senator Robert Peters, and State Representative Lisa Davis for a discussion about the findings and what we can all be doing as a community to ensure that our friends and neighbors are fully benefiting from the Pretrial Fairness Act. And so without further ado, I'm going to hand it over to Austin.
Thank you so much, Matt. Hi, everyone. My name is Austin Siegel. I am the Director of Research and Jill DuPont Memorial Fellow at Chicago Appleseed, which is a member organization of the Illinois Network for Pretrial Justice. And I'm very excited to present just some of the findings from our report. So first, we asked our court watchers to collect data on court demographics. And we found that 96% of the accused people in detention court were either Black or Latina, according to our court watchers, and a majority were young men. This is a byproduct of the racism in policing, and predictably, eliminating money bond was not going to be able to change this. Specifically, the Chicago Police Department and the Cook County State's Attorney's Office have largely targeted gun possession on the south and west sides of Chicago. For example, with the police specifically targeting Black and Brown communities on the south and west sides, and especially conducting pretextual traffic stops where they pull somebody over for a minor traffic offense and use that as an opportunity to search their vehicle. And our court watchers noticed this as well. One court watcher said, "What I observed was Black men being arrested for gun possession and even sought out by police." And speaking of gun possession, our court watchers found that more than 2/3 of the detention petitions in the courtroom they observed were for gun possession cases. I want to take a moment to distinguish gun possession from gun discharge or gun use. Gun possession only involves carrying a gun either without having the proper license or carrying a gun that itself is illegal in some way, for example, illegally modified, but it does not involve actually using or displaying a gun at all. And a lot of this, the prevalence of gun possession cases in these detention courtrooms can be explained by a lot of the policies under the state's attorney's office. Specifically, Eileen O'Neill Burke, in her first day in office, instituted a detention policy that requires her prosecutors to seek detention in any gun possession case where the gun was allegedly modified or untraceable, such as a ghost gun, or defaced in any way. Which it's important to note that those attributes are present in a lot of guns that young people are able to find when they don't have a FOID card, for example, which is the licensure you need to have a gun legally. And Eileen O'Neill Burke also eliminated felony review for gun possession cases, which means that the police are essentially able to directly initiate cases for felony gun possession charges without the evidence being scrutinized by the state's attorney's office, which clearly poses issues because that means that cases where there may not have been evidence for an arrest can make their way into a detention hearing and potentially result in jailing. And what we found with gun possession is that prosecutors and judges in detention court were inclined to regard anybody who was accused of gun possession as inherently dangerous, even though we know that many people who carry guns do so for protection rather than an intent to cause harm. And judges granted detention in a lot of these cases. As we can see on the next slide, judges granted 74% of the detention petitions that were brought before them in this courtroom, which is a very large number of these cases, especially considering that prosecutors' arguments tended to be pretty minimal and actually pretty inconsistent, as our court watchers found. It's important to note here that under the statute, prosecutors have the burden of proof in detention hearings, which means that judges should only grant detention if prosecutors actually prove in the hearings that the accused person does pose a risk and that detention is necessary to mitigate the risk. So we're finding that prosecutors are providing minimal and inconsistent arguments, often involving simply reading off of the police report directly without adding any nuance or arguments alongside it, and judges are often granting detention anyway. It's also worth noting that public defenders are at a disadvantage in these hearings because they have access to less evidence, and also the fact that I mentioned earlier with the felony review policy that prosecutors are failing to meaningfully assess charges before bringing these cases to detention court. And all of this makes it even more critical that judges engage in a really robust analysis of allegations rather than simply accepting what the state's attorney's office offers as fact. We also ask court watchers to collect data on the public safety assessment scores. That is the risk assessment tool that Cook County courts use to identify and estimate risk of the accused person failing to appear, being rearrested, or engaging in violent criminal activity. And 31% of the accused people in the detention court were deemed low risk by the courts. So you could read the report to see specifically what we are considering low risk based on the scores. And it's important to note that the risk assessment scores have a lot of flaws. They are certainly not a perfect tool, but it is worth noting that this is what the court is considering low risk. And even in the cases where the court deems the people low risk, judges are still granting detention petitions or imposing electronic monitoring in 80% of those low risk cases. And this is especially true for gun possession cases where, as we said, judges and prosecutors really deem people as a risk, even though a lot of people are carrying guns for protection. So, as one of our court watchers said, though the accused people never took their guns out or threatened anyone with a gun, they were still deemed a risk to the community and usually detained. In the report, which I highly recommend you read all of it because there's a lot more nuance, a lot more detail, and a lot of really great insights from our court watchers. It also includes a list of recommendations for the state's attorney's office, the chief judge of the Circuit Court of Cook County, and the Illinois General Assembly. We have a lot of recommendations in there, but if I were to name one for you right now, our most critical recommendation is for the state's attorney's office, and it is to end the blanket detention policies that require prosecutors to request detention in any case where certain charges and factors are present. We have a QR code here for you to read the full report. And again, I highly recommend you do it. But thanks for listening. I will now pass it off to Catherine Crawford, who is Senior Policy Advisor for the Illinois Network for Pretrial Justice.
Thank you, Austin. Good afternoon, everyone. I am going to start our panel discussion right away, and we will bring in Senator Peters, Representative Davis, and Public Defender Sharone Mitchell. And so I guess we will go in that order. I have a question for each person. I'm hoping that you could introduce yourself and speak a little bit about how you have been involved in the fight for pretrial justice. And we'll start with you, Senator Peters.
Yeah, so I'm State Senator Robert Peters of the 13th District, and I've been involved with this fight at least, I feel like, a decade at this point. First as an organizer and political director at the People's Lobby, and then I became a state senator in 2019 as a state senator, and then it's kind of crazy to be someone who was organizing around this and being part of this large statewide coalition to become a state senator, and then to be able to be the sponsor who's able to help get this done in the legislature. And this has been, my work that I feel so deeply attached to. It's part of my DNA, both as an organizer and as a state senator. And that's how I've been attached to this work.
Wonderful. Representative Davis?
Absolutely. So I am State Representative Lisa Davis of the 32nd District, which is mainly the South Side of Chicago. I am in my second year of my first term. So recently, as a new legislator, this past session, the Speaker placed me on the Public Safety Working Group. And the group was meeting mainly to determine whether or not we needed to review or make any changes to the Pretrial Fairness Act. As you guys are aware, there's been a lot of negative rhetoric, or I would say, individuals that are running for various elected officials or with the prospect of various elected officials have been creating this false narrative around the PFA. And so the speaker, being a true man of his word, said he had no problem with us reviewing it. So that's what the Public Safety Working Group was charged to do. The Republicans had filed several bills making suggested changes. And after reviewing a lot of those bills, we ultimately decided, before we were even contemplating making any type of changes to the PFA, that we needed more information. So that's recently, but as a lawyer with the Cook County Public Defender's Office for over 16 years, I've been directly in the trenches every day, dealing with these type of issues. I am still practicing in court when I am not in the General Assembly under the amazing leadership of PD Sharone Mitchell. So this has been a almost lifelong, at least half of my adult career. This has been a huge task that we as assistant public defenders have been facing every day.
Thank you. And we will ask you not just about your legislative priorities and experiences, but also as a public defender. And speaking of the amazing leader, public defender Sharone Mitchell, I'd like you to introduce yourself and talk a little bit about your involvement in the fight for pretrial fairness.
Well, I have real questions about whether I'm an amazing leader or not, but I have no question that we have 765 people that in this office that are committed to doing incredible work. My name is Sharone Mitchell Jr. I help lead the law office of the Cook County Public Defender's Office, and in my time as both a public defender and as an advocate for fair treatment of all people who are residents of both Cook County in the state of Illinois, I was blessed to be working with literally thousands of people that demanded changes to the pretrial system. As a young person, formerly young person, growing up in this community and as a young attorney in the public defender's office, I saw how the use of cash bond and the overuse of pretrial incarceration crippled the communities that I was from, the communities I grew up in. And there were people on the outside that aligned with people on the inside to demand changes to a system that, forcefully extracted tens of millions of dollars out of communities that didn't need it, didn't have it, made decisions within 30 seconds in a minute that would affect the outcomes of cases, and it really served as the front door to the problems of mass incarceration and wrongful convictions that our state unfortunately became relatively famous for. So I am blessed to help lead an office that is, attempting to do its best to implement this act, and really excited to be talking today with Representative Davis, who I think brings an incredible perspective to this work, given the fact that she is both a person raising folks, kids in this community, has practiced for an incredibly long time, and has this great insight. And Senator Peters, who quite frankly, just been the linchpin for this work, moving from organizer to legislative leader, and has helped, really keep tens of millions of dollars in the pockets of poor folks, and help to work toward a system that is far more fair and equitable. I'm so excited to be here to talk to y'all today.
Awesome. And I think that's a good segue into my first question for Senator Peters. As you mentioned in your intro, and as Sharone referenced, Public Defender Mitchell, the Illinois Network for Pretrial Justice spent 5 years working to get the pretrial fairness passed, and has spent another 5 years defending the law and monitoring implementation. And just to start us off, can you remind us why communities across the state came together to end money bond?
Yeah, I think there was a variety of reasons. Let's first start off. It's about the fact that we needed to have a reimagining of what it means to provide safety for people. You heard what Public Defender Mitchell said, which is we were able to keep millions of dollars in people's pockets so that they can afford to buy groceries or make sure that the kids have a backpack or shoes or be able to pay rent, instead of having a system that was basically holding people ransom and draining money out of our communities to put it into county governments that may not even come back to our communities. And so it was a movement that was driven about reframing what it means to have safety, reframing what it means to have comfort. And it was a movement to call out a system that basically held people ransom and included and impacted people who were family members or friends who were trying to help someone who may be stuck inside of a jail because they could not afford to pay bond. And then when we think about it, oftentimes we had this discussions, it was always sort of about Chicago, Cook County. When we talk about Illinois, when we talk about public safety, Chicago and Cook County not only just dominate in the state, but dominate in the entire country. But it turns out that this was a crisis throughout the entire state. Whether you lived in central Illinois, we had people who were organizing, for example, in Bloomington, Illinois, in Champaign County, Illinois. We had people who were organizing in the Metro East. We had people organizing in Rockford. It was the fact that we had a crisis in every corner and every pocket of the state when it came to public safety, when it came to a policy that was literally holding people ransom, and one that was ultimately unjust, not just in terms of the criminal legal system, but also in terms of the economic and racial justice fights in this country and in this moment. And so this was a massive organizing effort that really shout out to everybody who's doing this work, who's on the ground having those conversations with people, who are maybe moving people to reimagine public safety in a very different way. And because of the organizing, because of the statewide work, because of, we were in the right moment at the right time, we were able to strike and be able to get this bill done. And it's been truly a transformational piece of legislation. I mean, think about it. We're the only state in the country to have passed a policy like this. We have seen when I'm sure we're going to dig into this more, but there was often talked about like this is going to cause massive amounts of crime. We have seen historic reductions in crime. And I'm not saying it's because specifically of this bill, but it's because people have to have a more complex view when we talk about public safety. And this wasn't going to have the disruptions that everybody said it was going to have. And what it has done is made sure that millions of dollars are staying into people's pockets. And so instead of them having to spend even the relatively few bucks, but for working class people, that's a lot of money for them. They're keeping that for themselves to make sure that they can live the life that they deserve. And so it's been an unbelievable organizing effort, one that's rooted in the idea of economic, racial, and gender justice, one that's rooted that whether it's a rural community, whether it's a city, whether it's a suburb, that literally in every corner and every pocket, we have seen this crisis where people are losing their money or losing a loved one or both. And at the same time, we're watching as the county takes that person, takes that money, drains the community. And it doesn't mean that it's coming back to that person, coming back to that community.
Okay. And to that end, I mean, we talked a moment ago about the lengthy road to this, and it took the law took 2 years for implementation, for people to prepare, in part because it was such a big monumental change. During that time, many prosecutors from those jurisdictions that you're mentioning all across the state filed lawsuits challenging the constitutionality of the law, and ultimately those were consolidated and went to the state Supreme Court, who ordered the states to implement, ordered, pardon me, the courts to implement the law. After nearly 2.5 years of preparation, what did you think was going to happen when the law went into effect, and were those expectations realized?
Oh, that's a great question. I think, I definitely thought like this is just going to be a change that's going to give people more freedom, give people some level of justice in their life, that we wouldn't have to hear stories of people trying to just scrape by to get out of, jails that are literally 100+ years old, that are embarrassingly in bad shape with embarrassingly high numbers of abuse in them, that we wouldn't have to hear stories of maybe a loved one or a family member just begging to try to get money to be able to bond that person out and to pay that bond, and then also risking themselves the possibility of losing their housing or not being able to put food on their table, or the stories of people who might be experiencing a crisis because someone's locked up pretrial, particularly because they can't pay a money bond, and then having a family and then having to deal with things like DCFS. I mean, this change was in itself, a disruption of a status quo that fundamentally were failing communities. And so just the idea that we're going to shift away from that and shift away from those stories, and thinking of this as a place where it hits at the intersections of racial, gender, and economic justice. So I had that expectation. I think being someone who's as progressive as I am, who does this work, and knowing that there's so many naysayers and so many people who talk in these dire predictions, there is definitely a level of anxiety, right? Anytime you're making change, there's a level of anxiety that maybe the worst case scenario could happen. And so as you're organizing, you know it and you believe it's not going to happen. But there's a part of you that just sits there and goes, what if it did? And so what we've seen is that all those naysayers, all those people who trash talk this, all these people who did fear-mongering were completely wrong. It did not throw open the jail cell doors and do the worst things that ever could happen, anything, apocalyptic, because public safety is more complex than that. And when we look at these prosecutors who sued this, and we look at the political actors who spent millions of dollars attacking this law, and in fact, trying to make an election issue, we forget 4 years ago, in 2022 literally was a referendum on ending cash bail. We were talking about tens of millions of dollars being spent, including by people like Ken Griffin, who doesn't even live in the state anymore, to turn what we did into a referendum. And the people who tried to turn this into a referendum, or did turn this into a referendum, got their butts handed to them during an election. And it showed that the public wasn't taking up the snake oil that they were selling. And I think when we think about these folks who are literally were making these predictions and continue to engage in this type of disinformation, this type of misinformation, I think about people who really are engaging in a form of magic, an expensive level of magic. What they want to do is tell the public that when they pull the rabbit out of the hat, that it is real. When they're talking about public safety and they're doing the scare tactics, they're literally selling magic. It's not fact. It's not rooted in reality. And it's all built around the idea of them either trying to get themselves elected, or maybe it's the county that was literally stealing working people's money and using that to pay off something within the county, not necessarily for the people in the community. And so they didn't want to talk about how they were holding you ransom and taking your money so that they could fill a budget gap. They didn't want to do that. So they definitely know that they benefit from the sort of fear tactics that help them get elected. And so there was a political incentive, and there continues to be a political incentive to attack this law, to attack this work, and to go down this path. And I think for all of us, as we are now 5 years plus in terms of the law being passed, and a few years in terms of law being implemented, need to stay strong and hold strong. We're in a period where there has been a blowback around criminal justice reform, and things ebb and flow. But I knew when we passed it, the moment we passed it, was going to be hard to implement it. And I knew even when we implemented it, there would be people who in themselves would never let go of the political opportunism when it comes to attacking this law, or attacking reforms when it comes to public safety. But what I do know is that if we continue to stay strong, we continue to organize in every pocket of this state, and we continue to do this work, we can continue to make the changes necessary so that we have a justice system that actually works for working class people, a justice system that works for Black people throughout the state, a justice system that makes sure moms don't have to worry about a kid who may be held incarcerated because they can't afford something, or a justice system that makes sure that money comes into your pocket, comes into your wallet, so that you can have the grocery store that you deserve, and a public safety policy that understands that public safety is giving people the basic comforts that they deserve. What we can't have is a politics that takes us back. And there are definitely people, definitely state's attorneys, some recently elected, who want to go back to the 90s, an era which saw 1,000 homicides. They want to go back to the glory days where people were struggling when it comes to public safety. I think the things that we're trying to do is in sort of the reimagining is leading us to the path to public safety we all deserve. And so hopefully we continue on that path.
Thank you. And I think we're going to talk about one of those prosecutors and their efforts to challenge the Pretrial Fairness Act as we get into this. But I want to come to Cook County because that's the subject of the report, Public Defender Mitchell. And I know that Cook County undertook some significant steps to prepare for this historic transformation of our pretrial system. And I was hoping that you could talk about, a little bit about that preparation, and then what things looked like when the law first took effect.
Thank you so much for that question. As Senator Peters referenced, I think the authors of this law understood that this was a monumental change, right? It's a huge structural change that would affect every courtroom in the entire state, not just Cook County. So there was a kind of a 2-year lag period to get all of the education, the training, the SOPs, the forms, and then another 8 months to clear the legal challenges that happened at the last second. Here in Cook County, we have an adversarial system, right? No doubt about it, where prosecutors argue one side and defense attorneys argue another. But there are things that we can work together on to ensure that the system works at least as smoothly as possible in terms of like the forms and the courtrooms and how things would be heard, and there was a lot of work on that. I think internally the Public Defender's Office really wanted to be really well prepared for this law. So we took the kind of education and training seriously internally. We wanted to be, quite frankly, the experts on this new law. So we kind of, took our, created a new division exclusively around pretrial, trained those folks up, basically took folks back to law school so that we could, get that knowledge base going. And we knew that we were transitioning from a system where hearings, there was a sheriff study from a few, 2016, 2017 that talked about how the average hearing went from 37 seconds. And we wanted to go from that process where we had these really fast hearings and we had, hearings that were kind of closer to like, just like a kind of random selection of, taking the allegation, taking the background and coming up with a random number. So a really informed hearing process where you could get the most information possible to the judge. So that's work happened both externally and internally. And I think, quite frankly, that is one of the strongest benefits to this suite of changes, right? We're going from, the most important decision in a criminal case is innocence or guilt or dismissal. But the second most important is essentially what happens to that person during the pendency of their trial. And for a very, very, very long time, we did not treat that decision with the respect it deserved. We kind of ran through these hearings. We acted like we were renting the courtrooms by the minute. So we were able to move to a place where judges are receiving more information. The law is far clearer to make better decisions. It's not to say that the law is perfect, and we're going to talk a little bit about what's happening now, but we know that the law brought forth really great changes in just the sense, no matter what side you're on, that these decisions are far more informed because we know how important they are.
Also, I know that when, in addition to the work that the public defender was doing, the Cook County State's Attorney, then under the leadership of Kim Fox, and the Cook County judges were also preparing for the implementation. And can you sort of describe what it was like in the Cook County courts when the law first took effect in terms of pretrial detention hearings?
Yeah, well, we saw moving from that model of kind of 37-second hearings to hearings that were, 15 minutes, 20 minutes, where there was real information being brought before the judge so that a judge can make this really, really, really important decision. And it took a lot of work on kind of our side to get prepared for that entirely new culture of bond hearings where we weren't just like rushing through it. Back in the day, you could almost predict what the bond amount would be if you had the background and you had the allegation. It was quite frankly just like a schedule that we saw in other counties in the country, in the state, in other places in the country. So it was really our work was really about, this is an incredibly important hearing. How do we make this hearing important? How do we ensure that the prosecutor, has the ability to look at each case and decide whether a detention motion should be filed? And how do we ensure that if there's a detention motion filed, that the actors are giving the judges, the decision makers, the most decision possible? And how do we make sure that we have a clean set of really a law that is a suite of laws that is clean and not contradictory so that judges can make the best decisions possible? So a lot of the work over that 2 years and 8 months was preparing for that. And what we saw was very early on, a drop in the detention population, right? But we also saw hearings that I think fulfilled the desires of the framers, that they were really important, they were really lengthy, they were information filled, and they gave the judges the best pathway to make the right decision.
And I'm going to turn now to what was going on in court before and after from someone who was directly litigating. Representative Davis, I was hoping that you could tell us a little bit about how the Pretrial Fairness Act has impacted your clients.
Oh, most definitely. So I would say that there are real life-changing, significant impacts that are best illustrated by real life examples. And just, for the privacy of my clients, I won't use names. I'll just use, for example, client A or client B. So I would say I'll start backwards. So now take, for example, client A. Client A is a 25-year-old African-American male, a high school graduate, lives at home with parents, but is unemployed because he is the everyday caretaker for a grandparent, which oftentimes families find themselves in, right? They have a elderly parent or grandparent who they want to keep at home as opposed to placing them in a nursing home. Or any other facility they feel like they can best get that individual or that loved one care from, extended families or families within the home. So this individual was charged with a misdemeanor domestic battery while on pretrial release for felony retail theft. What I will say that PD Mitchell hit on the head was that now, under the PFA, we can have these more in-depth hearings where we are not being rushed, where we are making sure that we are getting out all of the information. So again, just the judge being able to provide the judge with information that this person has all of these mitigating factors. And in addition, Judge, he's unemployed right now. And not receiving any type of income because he is caring for this family, this family's loved one, and that's his role in the house. And unfortunately, while the family can't provide him with any type of income in caring for this elderly loved one because times are hard, this person does not have any significant background. You have the family in court. We can just make sure that we are flushing out all of those mitigating factors to get, this person, the client A in this example, released. And so while the state, of course, will say, well, Judge, this person picked up a new case while on your pretrial release, I'm also able to provide, well, Judge, the complaining witness did not show up on the last court date. Just being able to flush out these, what some might call trivial details, but now that we have more time to really have a longer drawn out hearing, these trivial details are most important. And they are important because these details decide whether or not somebody will be detained or whether or not they'll be released. So just being able to have that additional time, I feel is most beneficial to my clients. On the flip side, before the PFA, you are having individuals who might be also, so let's say client B, right, is also charged with a felony retail theft, and they have multiple felony retail thefts in their background. And let's say because there are underlying reasons of drug abuse or things of that nature in the past, this person might have been given, let's say, a $2,000 bond. And so while you might say, well, you only need $200 to get out, that individual clearly does not have the money to get out based on what they are charged with and what they have been charged with in the past. So here we are now holding an individual who does not have $200 to pay. So again, these are real life stories, real life impacts. So when you are, holding somebody at that time with a bond that they cannot pay, and what a lot of people, I think the state's attorneys and judges forget, once our office is, appointed to represent individuals, they are indigent, meaning they cannot afford a private attorney. So how can they afford a cash bond? You know what I'm saying? So it really made no sense that this person is not only being held on a nonviolent offense, but a bond has been given to an individual where you have appointed the office of the public defender to represent them, knowing that they are indigent. So when folks are in custody, that means that they are losing jobs. If they have jobs, they can no longer go to school or attend classes or various courses when they are being detained or in custody. Child care, so custody issues. Now do you have somebody that's going to take care of your kids? These are all life-changing impacts that our clients go through every day. And so I think the PFA has greatly, in a positive way, just affected my clients' lives because we are having these long drawn out hearings where we are able to provide more detailed information to, possibly, not have our clients detained. And also they can continue on living their lives, taking care of their children, working their jobs, and just pursuing other aspirations that they might have while they are awaiting trial, which is how it should be.
Hey, thank you for that. And our court watchers have found that decision-making has become less individualized and holistic than when the law first took effect. Judges are detaining people more frequently than they were before, and State's Attorney Burke has stopped allowing her attorneys to use their discretion as to when they request detention, as was happening when the law first went into effect, as you mentioned, Public Defender Sharone. And she, at the same time, she's eliminated felony review, which Austin talked about in his presentation, of many gun cases before they're filed. How have these changes affected your lawyers and their clients?
Well, I think that partly it's kind of frustrated. The purpose of the Pretrial Fairness Act was to ensure, and there are multiple purposes, was to ensure that if we had this discussion about whether somebody should be detained or not, that we had that discussion based upon the merits of the case and the merits of the individual, and not so much having blanket policies that guided what the state's attorney would do before the case was ever evaluated by the person who was in first appearance court making the decision. I think the purpose of the act was to get away from those kind of, among other things, those kind of very general practices and really add some depth to the decision making. And that hasn't happened. I think one of the things that you also that your court watchers probably saw is that time is limited in court. And one of the things that I think the act really does encourages those kind of very detailed hearings. But when you have a policy from determining that every single case should go to a hearing, you lose the ability, you lose the time to have those detailed discussions about what happens. The reality of the situation is that locking up individuals before there's been any evaluation by a judge or jury is an incredibly radical idea. It's something that both conservative and liberal courts have found to be supposedly the exception to the rule. And we have kind of moved into a place of mass incarceration and wrongful convictions, partly because of this addiction to pretrial incarceration, this assumption that every person who's accused is guilty, and that if let out, every single person will do the thing that they are accused of over and over and over again. And that kind of mentality has really guided the decision making, and it quite frankly goes against the balance of what we see happening in these cases. There's no doubt there will be individuals that will be accused of making mistakes again, but there's also no doubt that if we assume that every single person needs to be incarcerated, not based upon an evaluation of their character but just the fact that they've been accused of a certain offense, we will go back to the world of mass incarceration. We go back to the world where you have the sheriff going on 60 Minutes and saying that this jail is far too crowded. We will go back to a place where you have thousands of people pleading guilty, not because they think that they did it or the evidence is there, but because they're making just basic calculations about how to get out of the largest penalties. Again, I think the goal for many is just to ensure that we have that individual evaluation, and unfortunately, that goal is really being frustrated with some of the current practices.
And Senator Peters, I want to talk to you about why the General Assembly made the decision to give discretion to prosecutors as to when they would request detention when we are subject to, sort of the different priorities as prosecutors.
Yeah, I mean, the intent was not what we're seeing from the Cook County State's Attorney, which is not really in the service of public safety, not really in the service of the public in general. It's really in the service of a cover your ass political behavior. We gave discretion to prosecutors because the idea was that they should be able to determine in their mind what they saw as the most serious thing that they need to focus on. What we're seeing here is that if you decide to go and try to say everybody needs to be detained, it puts the onus on the judge to then have to make a decision. And the problem is, if you say everything's the worst thing in the world and everybody's the worst person in the world, it makes it even more difficult. And in fact, I would say can cause mistakes to happen. And I think those are things that we've seen in some of the cases that tend to get or some of the incidents that seem to get the most attention in the press. And so what we need are state's attorneys to realize that you can't just call, everybody and everything you see the worst thing in the world and seek detention for everybody. You should have some discernment about where you want to put that focus on, where you want to put that attention on, in the service of public safety. And so when we think about what does it mean, again, to provide public safety, we have right now a political operation that's in the interest of state's attorneys like the Cook County State's Attorney to do the most lazy, easiest public political way to do this. And it's not actually about the public safety. And let me show how this shows up in another way. Just recently, I think she had advertised something like thousands of signs she's putting on CTA about that if you do something on the train, you will be prosecuted. Yada yada yada. Now, I just want you to know that there are people on our public transportation system that are experiencing multitudes of mental health crises. And that's coming from things like the closure of our mental health institutions, massive disinvestment in our healthcare system. We already have a pretty, miserable healthcare system, particularly for working class people, people who've experienced massive amounts of trauma. Now, I want you, the public, to think about, and everybody think about, like, if you get on the train, do you think that someone going through that type of a mental health crisis is going to look at a sign and say, you know what, today's not the day. I'm not going to do it. Or a young person who's completely alienated, someone who's struggling. When I was younger, my mom was an alcoholic. She was very abusive. I did not necessarily have a lot of respect for authority. And when I was told not to do something, I did not necessarily listen. I wasn't looking at a sign and saying, this isn't it. I'm not going to do this now. But what that sign is, which is the same as what she's doing when it comes to seeking detention, is just to basically, again, pull a magic trick on the public. It's to pull a rabbit out the hat and tell you, look, this is very real. I'm actually giving you the safety you deserve. But it's not. It's not really doing that. In fact, it's a waste of money. That money could be used for things like what we see in Lake County with State's Attorney Eric Reinhardt, who's doing violence prevention programs to make sure that instead of doing this political game of just lock them all up, he's like, maybe we should actually intervene to reduce violence, and our office can be helpful in doing so. We could have a state's attorney that could be innovative in how they're using that powerful office to make sure to protect your safety. We could have a state's attorney that could be innovative and say, how do we make sure that we're doing some level of consumer protection and and worker protections? We could have a state's attorney that could reimagine what it means to provide safety and comfort for people in this county. Instead, what we have is the same old game, which is how can we basically sell you a lie, sell you a false thing, which is look at me, I'm asking to detain everybody with a gun. Look at me, I'm trying to keep you safe. Or I'm spending a bunch of your taxpayer dollars to put advertisements on CTA that nobody who may be acting antisocial is actually going to read. But you, the writer, will think I'm doing something. We need people who move away from this marketing effort of public safety and people who actually care about what's going on with everybody, and whether they live in the south suburbs, the west suburbs, whether they live in Lincoln Park or Hyde Park. We need people in leadership who are actually going to be rooted in providing the comfort and dignity people deserve. And so the reason why we gave discretion was for the hope that we would have serious actors in these positions who think seriously about how they keep people safe. And right now, what it seems that we have are people who want to make sure that they really score big on social media and really appeal to the particularly worst elements on Twitter and X. And we don't need that in our politics. We don't need that in policy. And that was not the intent of what we were trying to do.
Thank you. Representative Davis, I'm going to come back to you with two questions. So in light of time, I apologize for giving you two, but I want to get to both of these. I mean, one is, as Senator Peters mentioned, and as we discussed with Public Defender Sharone, there's a little bit of fear mongering. And to that end, our court watchers found that the overwhelming majority of people detained are charged with possessing but not using or displaying a firearm. The prosecutors are arguing that the mere possession of that gun makes someone inherently dangerous. What is your response to that argument?
It's foolishness, first of all. What we do know is people carry guns for most significantly because they are afraid, right? They might feel unsafe in the neighborhoods that they live in. The reality is you have to be at least 21 to apply for your FOID card. And oftentimes, regardless of what we might believe personally, I think our young people nowadays sometimes maybe even associate, if I can carry, then, that not only does it make me feel safer, but maybe I'm cool. Right. I don't intend to use this to hurt anybody. I just want to have it on me so that people are not approaching me, or people won't mess with me if I have this gun on me. I see it in court oftentimes, and something else that we are also seeing, if people are coming from states where there are open carry laws. So for instance, Indiana, and they are coming into the Illinois, specifically the Chicagoland area, they are being charged with these cases. And the first thing that they say to me is, well, I can carry in my state. And, when we are approaching the state trying to work these cases out, hey, let me show you this person's credentials from their state. They can, carry in their states. Yeah, they may not have had it, appropriately stored the way they should have coming into Illinois. But listen, this person has the state is absolutely stern and firm in their position. No, we're moving forth in prosecution. And it's like, well, why are you doing this? You know what I'm saying? And what I've heard oftentimes is because we are being told to do so. So that's a problem. That's a significant problem. What we do know is, whether it's a cash bond or detention under the PFA, just jailing people is not going to cure or correct gun violence, right? What we have to continue to do, not only in the legislature, but we have to keep having open conversations like this, right? At the local level, at the state level. The hope would be even at the federal level, right? To get all of the stakeholders on board to talk about these issues instead of coming down with these firm iron fist policies that I believe, Senator Peters just said, that are just marketing tactics.
So the other thing, and I know that we're really running out of time, but to the we do have these risk assessment tools that Austin spoke about in the opening, and we are finding that judges are detaining people who the tools themselves say are not dangerous or present a low risk. Can you talk about why this might be happening and why this pattern is concerning?
Oh, absolutely. What we do know is that judges are under an enormous amount of pressure, right? And I actually have a courtroom example from today where every time there's a high profile incident, You hear about it on the news or you read about it in the paper. And so that's concerning for judges, especially when they have to make thousands of difficult decisions every day. So in court today here at Bridgeview, in front of Judge Stephen Rosenblum, I was actually watching a private attorney represent his client. And the client was charged with, having a gun, but also domestic battery. And he scored a 2 on the PSA, and also proffered that the complaining witness did not want to come forward. And so I kid you not, verbatim out of his mouth, he said, well, when the paper goes to print, while you were released, your name is not going to be in it. Or I'm sorry, your attorney's name is not going to be in it. The state's attorney's name is not going to be in it. My name will be in it. Basically the negative impact of me releasing you is going to fall solely on me. And I just found that, compelling, because that's what I hear oftentimes, right? These judges are concerned with the quote unquote blowback that they might receive from releasing a client or somebody represented by, a private attorney, when the facts or circumstances might not be viewed favorably in the public. But what we also do know is jailing individuals or keeping them in jail for that sole reason, that's not the way to go either. As I spoke earlier about just the impacts to people's lives, people could lose their jobs, they can lose their homes, they can even lose custody of their children because they are being detained when all of the information is pointing the judge in the direction of release, but because they are concerned about whether or not their decision would be received, in the public's eye in a favorable way, that is seeming to be more important or most important in a lot of these situations.
Okay, we're going to wind this up with a question to each panelist. I want you to name one thing that you think we can do to work together to improve the implementation of pretrial fairness. And I will start with you, Public Defender Mitchell.
I think the Pretrial Fairness Act stands for a number of, I think, really important principles in our criminal legal system. The presumption of innocence, the reality that we shouldn't be forcing the extraction of capital out of poor people. The outcomes shouldn't be based upon someone's area code or what they look like or who they know. That decisions should be made on just not the allegations, but the facts brought forth to the decision maker. And that the decision maker should have the freedom to make the decision based upon the four corners of the case and not based upon kind of the other outside factors that could affect that person's livelihood. And I think that we are in a really scary place today, where oftentimes we are substituting good policy and good practice for a political gain, and that we're making decisions. And this has been an incredibly difficult problem in public safety, that we're making decisions that make us look like we're taking it seriously, but in actuality, it actually worsens outcomes. That the outcomes don't particularly matter more than the perception. And that's how we get failed policies. That's how we get communities that have been trapped in the cycle of poverty, incarceration for decades. But we get leaders that look like they're tough and act like they're tough, but we don't regard how effective they are in our evaluation of their jobs. I hope that we can support individuals like Senator Peters and Representative Davis, not just because I think they're right on the issues, but because I know that they're fighting for a world in which we're evaluating these cases not based upon just the kind of political nature of being tough on crime, but that they're committed to the communities and they want their community to be safe, whatever the outcomes will be. So we need to protect the Pretrial Fairness Act, and we need to protect those that are protecting the Pretrial Fairness Act. So that's my thoughts about it.
Thank you. Representative Davis, I'm going to give you a moment to answer, and then we'll close out with the person that we started with, which is Senator Peters.
Oh, absolutely. And I would say I wholeheartedly agree with everything that Public Defender Mitchell stated. I would just add, for me, we have to stop with the political gesturing, right? And using the PFA as the focal point, especially for individuals who have never been involved in this work, who have never had a desire to be involved in this work. I personally, I do take that personal, because as I've indicated, and also Senator Peters and Public Defender Sharone, we've all been, you know, in this work that is not always popular, right? It's not always fun. I tell a lot of people that you have to have a certain backbone, especially as a public defender. And me also being a state representative, I go to Springfield and everybody's fawning over me. Oh, Rep Davis. But then when I come back to the public defender's office and I'm doing this work, it's a different story, right? I'm walking into a courtroom where I'm facing opposition on every side from, because I'm advocating what's best for my client. So for me, I would say that I want to see more genuineness from especially individuals who are seeking or have, political aspirations, from our elected officials. Let's stop using the PFA as a negative soundbite, right? And really get involved, and be genuine in, the conversations to change.
Thank you. Senator Peters.
Yeah, I mean, I think of ending cash bail as actually sort of the starting point of something, not the end point of the work. And when I think about what we need to do is that we need to continue to push forward. We're in a period where we're talking about affordability. We're talking about an economic crisis. And we're in a period where we have someone in DC who also likes to play and make magic. Right. Just I feel like it was a week or two ago. He's trying, him and his Marco Rubio are trying to do another Red Scare and talk about Cuba and its infiltration in America or something like that. Whatever BS they need to do that's politically convenient. And I think we live in a politics where people are essentially doing a mini version of Red Scares and fear tactics for their own politics and trying to trick the public that they're trying to, that they're looking out for them. And I think that we need to continue to push forward. We've been able to pass the FAIR Act. We have to make sure that's implemented. That will, help us create a statewide public defender system, and one that is going to take a lot of work, a lot of effort. But we have to think about people who are living in areas that they, have have to travel massive distances. And when we think about some of those jurisdictions, they don't have the representation that they need, or people who are able to step up, or they had people who were at a very too close of a relationship to someone else, and it was not a fair system. It was not rooted in a level of fairness. So we were able to pass the FAIR Act, and a lot of credit goes to some folks in the Public Defender's Office and organizers around the state. We've been able to pass the Pretrial Success Act, and I think that's really sort of a starting point of what does it mean to make sure that we're providing services to people, to make sure they show up to court and make sure they have some stability. But we have to think about what government can do for people and the uniqueness of what government can do for people. For too long, we have seen a government that has been hollowed out by some of the richest people in the world, a level of privatization that has made people's lives more difficult. And on top of that, making their lives more difficult, leading them to go into desperate situations, leading them to a place of antisocial behavior. And so when I think about public safety, I think about using government to provide for people and to look out for people. And one way we can do that is thinking about how we reimagine what government does for you. What if we had our top lawyers at the state level and at the county level who were looking at people who were doing wage theft? What if we had a top lawyer in looking and making sure that, hey, how can we step in and prevent violence? How can we make sure we have less people we see in our court? If we had people in these positions who pushed the boundaries of public safety and used their bully pulpit and spoke out? What if we had a state's attorney that understood that the closure of a hospital is a public safety threat? Instead, of just doing what they're doing and hiding and making sure that they have the best messaging to get elected, not necessarily providing that safety? What if we had people who understood to step into the empty space and provide leadership that has been lacking in so many offices, not only just in this county and Cook, but in the state and in this country, who said, I'm going to be a leader to think creatively about how this will impact my office. And, you know, I'll end on this. We have an amazing county board president. And I'm going to quote her, but when schools were being closed, she said to the mayor at the time that you closing schools is going to fill up my jails. She was saying a school closure is a public safety issue, it's an antisocial issue, it's an economic justice issue, it's a racial justice issue. The county doesn't run schools, but the county was very aware that school closures impacted the county. We should have state's attorneys that understand that when different things happen in economic and racial conditions in this state, that they should be leaders who step into it. They should be speaking out about making sure our schools are funded. They should speak out and make sure that our hospitals are funded. They should be engaging to make sure that people have Medicaid, that someone comes in, if someone they see interacts with their office in any way, that they should be on top of making sure that they have their Medicaid. They should see themselves as bigger as just being the biggest advocate for jailing people. And it would be great if we had someone who was just, even in the most basic sense, speaking out about the actions in DC when it came to immigration and not hiding because they want to have a good relationship with the federal government during a time of immense pain in places like Chicago, in places like Franklin Park. We need leaders in these positions who have an imagination about how they can provide for people and how they can step up. And so it's our job to continue to organize that and to grab the attention and imagination of the public. And it's our job to make sure that people are put in those positions to look out for us and see themselves in a truly amazing leadership role, walking side by side with us. So that's my thought.
Thank you. Thank you so much. And thank you to the rest of the panel. I'm going to turn it over to Matt just to close it out.
Thank you all so much for joining us. As Senator Peters said, this work is just getting started. We have so much more to do to ensure that our communities are fully benefiting from the Pretrial Fairness Act and to hold our state's attorney and sheriff accountable. If you're interested in getting involved in our work, stay tuned to our social media as well as our website, nmoneybond.org. We have several events coming up in the very near future. On August 8th, we'll be at Access Living downtown with campaigns that are working to ensure that city, county, and state budgets are prioritizing our communities and not incarceration. I'll be dropping the registration link for that in the chat. We're also doing canvassing throughout Cook County over the next month to stop the Cook County Sheriff's Office from obtaining BriefCam, AI surveillance software he wants to use inside of Cook County Jail. You'll be able to find the recording of this presentation on YouTube, as well as the report, Changing Landscapes, at nmoneybond.org. Again, thank you to all of our panelists and presenters, and have a great rest of your day.